Objection, Your Honor, that is totally improper and offensive that an attorney would
It's
ask.
not offensive if the man says he's unemployed and has private counsel.
That's fine. Tough. Sorry, that's the way the system works sometimes. You don't get in, you're not entitled to get into my finances.
If you point me to the law, Mr. Pitaro, I'm happy to
I am speaking of
and
the
argue
law.
against it. But
You are totally out of line asking a question like that of an individual in a bail hearing.
and did you ever mention Jason Soto's name while in Reno Guns and Range speaking with Mark Covington?
No, sir.
Did you mention Chris Hicks's name to Mark Covington while in Reno Guns and Range?
No, sir.
Or my name while I'm Reno Guns and Range?
No, Mr. Stege, I did not mention your name either.
And so as a result, you would disagree that Mark Covington would then relay those statements to Detective Javi Lopez of the Reno Police Department.
I disagree with that, and there's a history between Mr. Covington and I that doesn't bear mentioning right now.
Oh, is there some animus from Mr. Covington that would cause him to falsely state that you mentioned those three names while in Reno Guns and Range?
Yes, there is.
Okay. And is it true that at the time Mr. Covington was working at Reno Guns and Range?
Correct. I ran into him as I was exiting the store.
And you knew him from his time as being the chief investigator of this office, the Washoe County DA's office?
And specific, yes, and specific involved in my wife's domestic violence case, correct.
Okay. And did you and Mark Covington discuss even your case, this instant case, while you were in Reno Guns and Range?
In a matter of 30 to 45 seconds, correct, sir. We did discuss the fact that I felt that his business was violating my Second Amendment rights. And his response was, I don't know what you're talking about. We had a few more words, and then I left the building.
Okay.
I did tell the person at the counter who I initially spoke to, who gave me the paperwork, not Mr. Covington, but the first employee that I met when I walked through the door to retrieve my firearm, that they were violating my Second Amendment rights, and there will be legal consequences for that.
Okay. Did you threaten to sue them?
Correct, I did.
Okay. Besides Ms. Lubitsch and the fellow at Reno Guns and Range, in the last year, how many people have you threatened to sue?
Objection, relevance. There's nothing to do with this bail hearing.
I agree. I don't see the relevance, Mr. Stege, as to any others.
Okay. Your testimony today is that you feel justified in the statements you made to Ms. Lubitsch.
Absolutely.
As well as the statements made to the clerk or the fellow at Reno Guns and Range.
Both to the person at Reno Guns and Range and to Mr. Covington, absolutely.
What is your financial ability to make bail?
I'm currently unemployed.
What is your PERS retirement value on a yearly basis?
I don't know off the top of my head, sir. I'd have to do research on it.
What is your monthly PERS check?
Again, I'd have to run downstairs and check the checkbook. I don't have that as a simplistic thought in the back of my head.
Okay, well, is it 10,000 a month or closer to 1,000 a month?
I wish it was 10,000 a month, closer to between 1,000 and 2,000.
Okay, and is there anyone close to you who would able to post bail for you?
Objection, Your Honor. The fact of someone posting the ability to post bail for someone is not relevant to his economic status.
Well, it's a bail factor that the court is to consider is the ability to post bail.
His ability to post bail, not some unknown person that he may have to solicit to post bail.
Well, it's,
And you don't post bail until you go through a whole bunch of other things.
right, but the question is, if this court were to agree with the state and the man is required to post bail, how much skin in the game the defendant would have if it is his own money or the money of a wealthy benefactor that could post the bail.
I'll allow the question at this point.
Mr. Stege, I'm currently unemployed. I've been applying for numerous jobs, but ever since this situation took place on me in August of 2019, it seems to me that I've been unable to obtain permanent employment, but yet I'm still trying. My wife is currently unemployed, however, volunteers her time because she's unemployed because of the COVID. And I'm currently trying to obtain gainful employment. But as we sit here as today, I am currently unemployed. I don't have any wealthy benefactors or any goose that lays a golden egg to help me out with any type of bail. My parents are both deceased, and my in-laws are within sick health, and they are out of state.
Is it true that you did at one point have a wealthy benefactor who did pay for Mr.
Objection, Your
Parker?
Honor. I mean, this is so far-fetched over what is filed in this motion of wealthy benefactors, friends who may be able to come in and do things. The issue before this court is really quite simple. Did he make threats against people, telling some physical threats of violence, not whether he's going to sue somebody?
And Mr. Stege, I think you've made your record as to the bail factors that you're discussing. So let's ask another question.
Did you pay for Mr. Pitaro's retainer?
Objection, Your Honor. That is totally improper and offensive that an attorney would
It's
ask.
not offensive if the man says he's unemployed and has private counsel.
That's fine. Tough. Sorry, that's the way the system works sometimes. You don't get in, you're not entitled to get into my finances.
If you point me to the law, Mr. Pitaro, I'm happy to
I am speaking of
and
the
argue
law.
against it. But
You are totally out of line asking a question like that of an individual in a bail hearing.
So again, I don't think it's relevant. I believe Mr. Stege has already made a record of what I suspect he's going to argue. So
nothing further. Thank you, sir.
Mr.
I
Pitaro, would
do
you follow
just-
up questions?
Yeah, one quick, it'd be a follow-up, but also a little one. Mrs. Stege said that you've never had a bail hearing. Did you appear in front of a magistrate when you were first arrested?
I did.
And did that magistrate make a decision as to your bail status?
She did. She's on this court proceeding right now. Just
Okay.
she's
And
right.
after she did that, did she also place a condition upon your release over and above the own recognizance release? That is, you have to report into him.
Yes, I'd have to report into Mr. Mendoza weekly. And actually, initially, before the COVID virus took place, I was actually physically reporting into him. And then once that happened, I was actually calling in on the phone line.
Okay.
And I kept Mr. Mendoza.
All right, wait a minute, let me ask the question. All right, so you have been reporting to Ms. Mendoza for the past year and a half or so?
Yes,
Is that correct?
correct. Yes.
All right, has you had any problems with that Mr. Mendoza brought to your attention that you were somehow violating any terms and
I
conditions
object to the
of
scope.
your release?
This was not a subject of direct.
Sure, was you asked, was he in bail? Then I'd ask to reopen.
I will allow Mr. Pitaro to address the bail factors as well.
Okay.
Go ahead, Mr. Pitaro.
And you've been on supervised release for a year and a half.
Yes, sir.
And have you had any problems?
No, sir.
Has Mr. Mendoza ever made any comments to you concerning about your performance on supervised release?
Well, this recent comment is I've been stellar with him.
Okay. I have nothing further.
Anything else, Mr. Stege?
Yes, sir. What does supervision entail for you?
Supervision entails abiding by all rules and regulations set forth by the court and obey all laws. Don't get yourself in trouble. Don't get arrested. and check in weekly, which I've been doing. And I'm
Right.
not-
So, but Mr. The officer, has he ever been to your house?
No, sir, and he's more than welcome to come.
When was the last time you saw your officer in person?
Been quite a while, right before the virus went into the pandemic state.
So over a year, right?
Yes, correct.
And so when you don't physically see him, what do? Call in?
I call into the number that's provided to me and I check in every Friday.
And so when you call and check in, you don't even speak to Mr. Mendoza, do you? You speak to a computer,
Correct.
and you just have to punch in some numbers or something.
There's two numbers to utilize, number 1 or number 2, and I think I've got those pretty well memorized.
Okay. And when was last time you actually spoke with your supervising officer?
Today's Tuesday, so it would have been Friday. I spoke to Carlos Mendoza, would have been Friday or Saturday when I actually told him about, or let him know that this hearing was coming up.
Right. And before that,
And that this motion that you submitted was put forth.
and before that, you hadn't talked to, you had just been doing the phone check-ins by calling and pressing in numbers.
Yes, pretty much, correct.
Okay. And so it was really the pendency of this motion that brought either you to his attention or him back to you, where you both spoke to each other.
When I received the motion from my attorney, Mr. Pitaro, I made an effort to contact Mr. Mendoza to kind of give him an update whether he did or didn't about this motion that you had set forth, Mr. Stege.
Okay. But there's no limitations on where you can go, are there, in the court?
Actually, if I plan to go out of the area or out of the state, I will contact Mr. Mendoza. Actually, I did contact Mr. Mendoza when I made a recent trip to the Las Vegas area, and he said, go ahead and go. Other than that, I have not been out of the area, and I've been abiding by all rules and regulations set forth by the court.
But you're not required to do that. It's just a thing you're doing on your own.
I'm doing it on my own. Yes, sir. Correct.
If this court were to order that you not possess any firearms for the pendency of the case, is that a condition you would abide by?
Certainly. If you want to come take the firearms, and if that's the pendency of the case and all parties feel great, if that's the crux of the matter, I have no problem. I do feel that my Second Amendment rights would be infringed upon, but if I agree to it, then we can just toss that off to the side. I have no problem whatsoever.
Is there a third party, someone not related to you, that could take possession of any firearms in your possession?
There's many third parties I could go to if that's a bone of contention. Correct.
Okay. Thank you, sir.
Thank you.
Mr. Pitaro, anything further from Mr. Handte?
No, Your Honor.
All right. Mr. Pitaro, do you have any other witnesses you'd like to call today?
No, Your Honor.
All right. Counsel, are we prepared to turn to argument, Mr. Stege?
Yes.
Go ahead.
I've previewed my argument, Your Honor, but the concern of the state is, I'll put it in simple terms. I have a moderate amount of time doing this work, and this case stands out as the first defendant to have made such statements while in a gun store that included both my name, my boss's name, and the chief of police's name, accompanied by the words "is going to pay." So troubling in that Mr. Covington, a former employee, the chief of this office, that those statements were made to him in a gun store. I mean, in a gun store is beyond the pale, I suggest. And then the follow-up, we're making these equally problematic statements to our witness here in the case. That is concerning to the state, as it should be to this court. Mr. Pitaro, I think inadvertently handed me a metaphor. He said, well, Mr. Handte it's like going to the DMV. You're standing in one line for a long time, then you got to go to the other. That's the exact problem. That's a thing that happens to a lot of people. You get frustrated with a bureaucracy or a person at the DMV. The difference between most people and Mr. Handte is the way Mr. Handte reacts. And both of those are problematic. This court has the power, as I pointed out, to reasonably restrict the defendant's conduct pending the outcome of this case. This court also has power to impose money bail. Now, traditionally, Mr. Handte would be an ideal candidate for an OR, right? No criminal history, established times here in the community. But as his behavior has dictated, he ought to now have some, I would say, more skin in the game, on that being money bail. And so my request is a $10,000 bail. I also ask that as a condition, and even if the court were to disagree with me on the amount, that the court could still, on the current status, increase his supervision. Now, I am, and many in my office are, critical of the pretrial supervision because we have a thing we call intensive supervision, which, as the court knows, is nothing more than more phone calls to a computer compared to regular supervision. Nonetheless, intensive supervision, as it were, could be ordered, but restrictions on the defendant possessing firearms is reasonably and closely crafted to the danger that the defendant has represented himself to be. That question of character, which is, it's actually in two places in our bail statutes, 178498 sub 3. It's also in 1784853 sub 4, talking about the defendant's character. I humbly submit that there is a question of temper or temperament with the defendant in these two distinct instances that the court, balancing the safety to the community, ought to address by the conditions I mentioned. I don't know if no alcohol was ordered, but that's another condition that the court ought to address. And the defendant's testimony today, there are some sort of credibility issues with the defendant's testimony, and I submit. Thank you.
Thank you. Mr. Pitaro.
Thank you, Your Honor.
I find you in contempt. I am going to incarcerate you.
pursuant to that Supreme Court rule, your death penalty is qualified.
Please put in writing your concerns or objections.
Any statement that you make is under penalty of perjury.
No, that's not how that works.
We will take this case under submission.
That would require proof by very significant evidence.
I want them to be present, and I want to be able to see them throughout these proceedings.
I said in my response, I think this was a misplaced motion. I even feel more strongly now. The function of bail has been set forth once again in the definitive way by Justice Handte and the Valdez case, dealing with the abuse, quite truthfully, of bail that is and the bail issue that is involved. I cited the court to a case that Justice Stege did about 4 days ago on reversing a denial of bail on a capital murder case, allowing for the state to engage in speculation that this was happening or that wasn't. As I said, that was what I think we got the advance sheet out like Wednesday, and we cited that in there. So this is an ongoing issue. The court has the burden, and the burden they have is one, according to the Valdez evidence, is that they have to prove by clear and convincing evidence that the person is in fact a flight risk and or he is a danger to the community. Obviously, someone who has lived here for over 40 years seems hard pressed to be a flight risk. The issue of character, someone who is a retired in good standing highway patrolman, former sheriff of one of the counties, one of the Native American reservations. It shows a person who is just a little above the cut in what he's done in the area of law enforcement. Now, the other thing to consider in this is that the timing of this, because the state has argued on the one hand, well, we don't really care what the reason was or why, but we really want the court now saying the 922 win doesn't deal with firearms. Let's ask the court to do it. And quite truthfully, that is why I think I put in there the idea of wondering about the timing and the tenor of, in fact, this motion. But let's go to some of the things the state has alleged. Have they proved by 20 years ago, they put in a motion that a guy kicked the garbage can. I mean, with all due respect, that seems to be one of the most absurd assertions in a judicial proceeding dealing with whether a person should or should not be continued on bail on the same conditions. 20 years ago, and and then the statement that was made, nothing happened by it. I mean, one wonders how they even would have found out about that, seeing his personnel records have been closed for years and there was no report of it.
That's not a fact and evidence.
But nevertheless, this thing is so old to be laughable. Now, let's move forward on it, and let's deal with the timing of this. As I put in there, and as I pointed out, after Mr. Handte had this conversation with the person from DPS, he called me and asked me to
Same, not in evidence.
look, neither was the ideas of what you put in your motion not in evidence. This is what we're arguing.
Well, we just had an evidence hearing, sir. Your Honor, you can't say my client called me and this is what he said. If he wanted to do that, he could have, or if he wants to call him now and have him say that, I can cross-examine it. And an attorney is not a witness in a case.
I agree, Mr. Pitaro. Let's limit it to the motions and the testimony at hand.
Well, I am, Your Honor, and the issue is that we put it that the evidence in the motion that is the matter of the record is that I called the Deputy Attorney General on the 22nd, and immediately after that is when this police report comes in dealing with things that happened last September, and then this motion comes in so quickly over Mr. Hante's bail status. Now, let's look at the past year and a half. Now, maybe the state doesn't like the fact that the courts have set up a method of people checking in on a weekly basis, or however basis it is. This is one of the more newer innovations that have come up in the last few years of a way to sort of deal with the problems in the state. And Mr. Handte has been doing that at the court's direction. He didn't do it on his own. It was this court that told him to do that, and he has done it. And during that period of time, he has not had one problem. As a matter of fact, he told the court, he just spoke with Mr. Mendoza and asked him about that. And the court is free to ask Mr. Mendoza. Now, Mr. Mendoza, of course, as the intake officer, is to notify the court when there are problems with person on the intake, and there has been no indication or evidence there is. Now, I know district attorneys don't like the idea that people are able to call in without some sort of more difficult hoop to go through, but that's the way it is. And generally, it works very well, and we're able to find out if a person has done anything untoward while out on supervised release. Well, in this case, we know nothing has happened untoward. There has been no allegation made at any place that he's done anything during that period of time, save and except, as he said, which as a matter of law, the possession of a fire or the sale of a firearm, as we pointed out, would be verified by the ATF. The state has made no attempt to do that to see if this was in fact it. The court knows, and I'm sure the state knows, is that when you transfer firearms from state to state, you do it through licensed firearm dealers. That's in fact what Mr. Handte did. The state also knows, and that the court knows because you've seen it in there, that United States Code 922N says a person who is under indictment cannot have possession. It doesn't say a person who is under criminal complaint can't possess a weapon. And that was the dispute. And quite truthfully, Your Honor, I don't know about others, maybe it's my Italian heritage or whatever, but when I talk to people and I know what the facts are, and they tell me that I'm wrong, then that does get people upset. And as she said, it is very, very common that people get upset with her. And she said that he really wasn't that much out of line with others. Now, what was the thing that he said? He was going to sue her. Quite truthfully, the people who really believe in the Second Amendment think that is something that they are entitled to enforce. And they're 100% right. And so bringing a lawsuit and threatening a lawsuit is an entirely different matter than threatening, I'm going to wait for you after work and hit you over the head with a sledgehammer. Now, the idea of whether he did or didn't, Mr. Handte said he didn't, others say he did. It really appears it's the idea that he has included his unhappiness with the prosecutorial agencies of being involved in what he considers a denial of his Second Amendment right. Once again, there's nothing that makes that clear and convincing evidence that he's violent. If he was violent over these things, something would have happened in the last 20 years. And there's been nothing like that. And, you know, when we come in after a year and a half and say, oh, we didn't have a proper bail hearing, let's have one now. I don't think that is in fact correct. The Supreme Court said that the people who are arrested would be brought in front of a magistrate immediately and having a hearing. He had that hearing. If the state sent down a representative at that time, that's fine. That's what they were doing in Las Vegas. Sometimes they do. Sometimes the people don't show up from the state. But the point is, yes, he had his hearing. There is nothing in there to indicate that any of those terms and conditions should be changed. Remember what the state started with. They wanted a no bail bench warrant. They wanted to be taking custody without any bail. Now, that case that I just cited from 4 days ago clearly said you can't do that. And yet the state is still out. You haven't been able to do that forever. It's just the state the Supreme Court has to just periodically go back and tell the state, these are the rules that have been set in motion for decades. But nevertheless, that's where we're at. He has in fact complied with all the conditions that you set upon him. He has not done anything about except getting frustrated. If you want to use the word bureaucrat, I don't think I did, but if you want to do it with a bureaucrat who is insistent that they're right when it is manifestly obvious that they're wrong, or that when they say you're under indictment or information, when that isn't true, and when you show them and tell them that you're in justice going on the criminal complaint and you're dealing with that, and they're not going to take any time or effort to even look to see if you're right. They're just going to deny what you're saying. When they say, well, you can't purchase the gun, he said, I'm not, it's my gun. I've owned it forever. That does frustrate people. And it's not a crime to frustrate people. And it's not a crime that people get frustrated. Not unless we wanted everyone to be on heroin, and then no one would be frustrated. But this is what has happened. He has done everything that he is supposed to do. He followed through with it every way he is supposed to do. And it becomes punitive. It becomes punitive for this court to change those bail conditions based upon what the motion sets forth and based upon what we heard today. He's no threat to anyone. He may sue you. He may bring legal action against you, but he's going to not knock you on the head. He's not going to flee. He lives here and has been here, and he has been on supervised release for a year and a half. And I would suspect that this court has not had one complaint against him by Mr. Mendoza. If I'm wrong, please tell me, but I don't believe so. And I know that the pretrial intake officers are supposed to notify the court when there are problems with someone on supervised release. So I think the condition of the bail that we have is sufficient to when we have our preliminary hearing, whether it's in 3 weeks or 4 weeks or whenever we can schedule it. But this is not the sort of hearing that we should be dealing with, of changing bail statuses, asking for money bail, that there's no other way but putting money on. There's no other way but taking away his Second Amendment right, when this whole issue really started over a bureaucrat misreading the statute, which is in front of the court, which is misreading their own document, which is in front of the court. And the court knows that the only thing he has is a criminal complaint, which doesn't fall within that, which he was 100% true. You don't get your bail status changed adversely because you're 100% right. With that, I'd ask that the motion be denied and we go on the way we've gone on and get our preliminary hearing done and see if the state can establish a probable cause. And then if they can, at that time, we can deal with this issue. If they can't, we don't have to deal with any issue.
Thank you. Mr. Stege, since this is your motion, you have the right to the last word here. Is there anything else you'd like to state?
yeah, I should win this motion, Your Honor. The argument we just heard, talked about everything except for what was relevant. It's sort of classic look the other way. Turn this thing with Ms. Lubitch into the wrongfulness of Ms. Lubitch and the righteousness of Mr. Handte's anger. This isn't about Ms. Lubitch's interpretation. A professional who deals with angry customers all day, and here is Stu Handte standing out with his hot-headedness, his sort of his character flaw that he flies off the handle and says, "What are you going to do? Send the ATF to my house, and they won't be able to find my guns." This statement about a potential straw purchase. We didn't hear anything about that except, well, Mr. Handte was right to have felt that way, and Ms. Lubitch was completely wrong and thick-headed and the rest of it. The court saw none of that from her demeanor this afternoon. Completely professional, and Mr. Handte, the complete opposite. And that statement about going to do, well, ATF won't find the guns, and the statement about doing potential straw purchase, that should be problematic for the court that demand. It's exactly like when he tried to lecture the state about how cross-examination should work, right? If I don't believe in it, I'm not going to comply with it. If I don't like the question, I'm not going to comply with it. If I don't like the interpretation, I'm going to make hot-headed statements. And that on the back of him making these statements whilst in a gun store and asserting wrongly that Mark Covington made this up because of some past interaction or some past issue between himself and Mr. Handte. Now, again, absurdification. My point in my motion isn't that Mr. Handte kicked a trash can, but it's absurdified to be like, look, 20 years ago he kicked a trash can. It is of equally poor judgment when being relieved or fired or told, get out of this building, whatever the case may be, to say I could fucking kill him. Now, Mr. Handte today, pointing to an issue with his credibility, says, right? Kill means kill M, apostrophe E-M. Again, sort of this real problem with the defendant's hot-headedness. That is a problem for, I think, squarely for the court, unfortunately, that a man who otherwise would be a good OR candidate is out there putting the names of the chief of police, the district attorney, and the prosecuting attorney on his mouth within a gun store and making those statements. But we didn't hear much about, in fact, nothing from Mr. Pitaro's argument. Again, that absurdification, blaming it on bureaucrats rather than squarely where it is, which is on the defendant. Again, further absurdification, questioning the motives of the prosecutor, right? The timing, well, without addressing the heart of the issue, which is this man, based on these statements, they are sort of unusual and compared to what we deal with, make him a threat. This pointing to, again, absurdifying, well, if we knew something was wrong, Mendoza would tell the court, there aren't that many conditions. What could he tell him? The guy missed a phone check-in. That's a very low baseline based on what we've learned through this motion practice. That baseline, that minimum supervision, meaning call on the phone for a year, pressing a number or another number, is insufficient in this case, given the magnitude of the defendant's threats. I stand by my motion, my recommendations. Thank you, Your Honor.
Thank you. So this court is called upon frequently to determine issues regarding further conditions of bail and modification of bail after bail has already been set. There's nothing unusual about such a request. Sometimes the court increases the conditions if if necessary. Sometimes the court decreases the conditions if necessary. So this type of hearing comes before the court frequently. There's nothing unusual about a request, and the court has the power pursuant to statute to make these type of determinations on alleged subsequent conduct of defendants after a bail hearing. So the court has the ability to increase conditions, decrease conditions, things of that nature. What we have in my mind, which is the foremost concern, is the alleged statements regarding Jason Soto, Chris Hicks, and Amos Stege that I believe Mr. Stege in the exhibit indicated that Mr. Handte said they will pay. That in my mind is the foremost concern here, not the arguments that Mr. Handte and Ms. Lubitsch may have had back and forth about his gun ownership. That's not what this court is here to litigate, frankly, and that is a concern, but is not my utmost concern. My concern, which again, I agree, it wasn't addressed nearly as much in this hearing as was the conversations with Ms. Lubitsch, is the alleged statements which Mr. Handte has denied making that those individuals will pay. That is my concern. So, given that, I did look back to Mr. Handte's pretrial risk assessment in this case that was done. That's a tool used by the state of Nevada in determining, giving the judge more information to make a decision at the time of bail. Mr. Handte scored a 0 on that document. That's obviously the lowest score you can have. He scored a 0. And he is on supervision with Carlos Mendoza, and that supervision is pursuant to however pretrial services recommends he be supervised. During COVID, I agree with Mr. Stege. They have had to resort to making more phone call type appearances because of the nature of COVID. I don't know if that will be changing now that our Washoe County is hopefully coming out of the COVID pandemic and the numbers are decreasing or not. That's pretrial services is a different department from Reno Justice Court. So they handle those decisions there. But I certainly have not received any information that Mr. Handte has violated from pretrial services point of view. Those things being said, I do not think that monetary bill is appropriate in this case. Mr. Stege requested $10,000. I don't think that pursuant to Valdez Jimenez, which is the controlling case law regarding bail in Nevada, that case law states that the least restrictive means needs to be pursued to accomplish the goals of ensuring that defendants both appear for court appearance and community safety. I think here, the least restrictive means is to indicate that Mr. Handte is not to possess or have under his custody or control weapons of any kind. This is only during the pendency of this case. This is not talking about who actually owns these firearms. I'm not making any decisions about ownership. All I am saying is during the pendency of this case, for that period of time only, those weapons that Mr. Handte may own have to be outside of his custody and control and possession. Mr. Stege asked questions about are there third parties available that those weapons could be stored with temporarily during the pendency of this case. Mr. Handte indicated that there are many individuals that he believes could potentially safe keep those weapons for him during the pendency of this case. So again, I'm not litigating his ownership over these weapons, but I am saying, based upon what I've heard today, that there may have been words from Mr. Handte in a gun shop regarding these 3 individuals, although Mr. Handte has denied it. I think it's appropriate to say that during the pendency of this case, he's not to be in possession of or control of firearms. And so we will communicate that obviously to pretrial services, and Mr. Handte will need to take steps to ensure that if he does currently have firearms in his home that are under his possession or his control, that those need to be, again, placed in the third party's hands for safekeeping during the pendency of this case. He's going to continue to be on supervision with pretrial services. If pretrial services believe that additional check-ins or more check-ins of Mr. Handte than they've been doing are appropriate, they can certainly do that. I leave it to their discretion how they're supervising Mr. Handte. But pretrial services has the ability, again, to require how often Mr. Handte checks in, how those check-ins are done, whether it's by Zoom, by phone, or other means, and they can certainly adjust that as they see fit. But I think that certainly a no weapons clause during the pendency of this case is appropriate. So, Mr. Pitaro, I will trust that within the next 2 days, Mr. Handte will make those arrangements. Is that unreasonable, a 2-day time period?
It's going to be difficult for me to, like till Friday. I have 2 doctor's appointments in the next 2 days, so by Friday I can make sure it's done. And do you want us to engage Mr. Mendoza, or how do you want that to happen? You want him to?
The court clerk will let Mr. Mendoza know the outcome of this hearing, and that an added condition has been made to Mr. Handte he's not to have any weapons under his custody or control. I think again that 48 hours should be enough time to make other arrangements. If it's not, please reach back out to Mr. Mendoza. And if we need to have further discussion about it, we can. But I certainly think that given Mr. Handte's testimony today, that there are numerous individuals that would assist him with this, that it shouldn't be a problem.
I don't know what I'm actually talking about is, are we going to, do you want a list submitted to Mr. Mendoza as to who has those firearms, or do you want that list to be submitted to me and me to hold it in my file?
So I think that the list can be submitted to Mr. Mendoza, and I think it would be appropriate to be filed as well.
Filed as in the court proceeding?
I think if Mr. Mendoza has it, it can be filed with Mr. Mendoza, and I think that will be appropriate.
Oh, okay, that's fine. That's fine. Thank you. And
all right,
we'll try and get that done so we can get that to him by Thursday afternoon.
Anything else, counsel, given that that's the ruling today?
No, Your Honor. Thank you.
Will the court make sure the minute order that this decision is reflected in the minutes?
Yes, obviously records are kept. This will be reflected in the minutes.
Very good.
And counsel, just as a reminder, please reach out to the clerk so that we can set the preliminary hearing.
Will do. Thank you.
Thank you, Your Honor.
All right. Thank you all for being present this afternoon. That ends this hearing, and we will all log off at this point. Thank you.
Your Honor.